to this, Advocate Zandile Mshololo has agreed to dump her special entry application on docket number 375. But she now says that she wants to lead with hearsay evidence from General Johan Ndlovu. It's Brigadier Johan Ndlovu, rather, who is now deceased. Mshololo represents accused number 5 in the Senzo Meyiwa murder trial. Judge Chipiwa Maumela has now given Mshololo the go-ahead, and our reporter Slindelo Masikane is standing in court to give us more details about this. Slee, this trial is one of those that has had application after application within it. Of course, we heard from Mshololo today in terms of that application for hearsay evidence to be admitted.
Yeah, so of course she abandoned her application in terms of a special entry because after a consultation with the judge and counsel in chambers, she conceded that the judge has in fact noted the fact that there's an irregularity in terms of the fact that she did not receive full disclosure prior to the trial in terms of docket 375. Of course, then Sergeant Thabo Mosia, the forensic investigator, who is still under cross-examination, was then going to resume testimony and that cross-examination. But before that, Advocate Mshololo then made another application to have hearsay evidence admitted, and this is in relation to a statement in docket 375 by General Johan Ndlovu. At the time of his passing earlier this year, he was the head of detectives here in Gauteng, and of course had been promoted to a general. But at the time of the murder of Senzo Meyiwa, he was still a brigadier, and in fact one of the first police officers on the scene, and was the one to call Sergeant Mosia to the crime scene. And in fact a lot of the testimony by Mosia alludes to the fact that it seems that he was assisted by Brigadier Ndlovu in terms of collecting evidence at that crime scene. And so what Mshololo was saying to court is that it's in the interest of justice that we have this particular affidavit read into the record, even though Ndlovu is not alive to be able to confirm it for himself. But she says that to be able to ascertain that in fact Ndlovu did write that statement, she is willing to call the police officer who commissioned the statement, that is Joyce Buthelezi, who is the investigating officer of docket 375, in order to be able to confirm the authenticity of it. But let's just take a listen to her submissions in terms of why it's important that we hear what Ndlovu said in his statement in docket 375.
My Lord, I would like to bring the application to lead hearsay evidence in terms of Section 3, subsection 1C of Act number 45 of 1988. In order, my Lord, to lead the statement of the witness, Johan Ndlovu.
You said in terms of?
Section 3, subsection 1C of Act 45 of 1988.
Yes.
The reason, my Lord, being that the deponent to the statement that I'm intending to refer the witness before this court is no more. He had since passed away, and therefore he cannot be called to come and confirm the credibility of this statement. However, my Lord, it is my submission that it is in the interest of justice that the content of this statement be read into the witness, who is currently in the witness box, for him to respond.
And Slee, yesterday during Mshololo's application, the state said evidence in 375 could be used during cross-examination, but today opposing her application. Why were they opposing the application to have this evidence actually admitted?
Well, they were saying that it's not in the interest of justice, and that in fact, the statement that Ndlovu had deposed should not really be put to Mosia, because he's going to have to answer to things that he may not know anything about. But of course, that was the state opposing the application. Let's take a listen to State Prosecutor George Baloyi.
Already traveled down this road. The court will recall that Advocate Tifo tried to cross-examine the witness on that statement, and the state objected, and even if there was no formal ruling, but Advocate Tifo then abided by the objection and did not pursue the matter any further. Section 3 of Act 45 of 1988 that my learned friend wants to make use of mentions 3 possible bases for admissibility of hearsay evidence. The first possibility is by consent. We're not consenting to that. The second ground is testifying by the person on whose credibility the value of the hearsay depends. Obviously, this is not possible in light of the demise of the witness. And thirdly, judicial discretion in the interest of justice. And that is the ground on which my learned friend is basing her argument.
And the Judge Slee ruling in the defense's favor?
Ruling in the defense's favor, saying that the interests of justice actually permits that the statement be read into the record. Also saying that the integrity of the criminal justice system is basically at stake here. And so we need to certainly hear what is coming out of the second docket. Let's take a listen.
Court ruled that the statement by Brigadier Ndlovu shall be read. Amongst others, the reason why the court ruled as such has to do with the interest of justice. That we have heard about the first and the second docket. This statement is about, or was made by somebody who was even responsible for directing you.
All right, Slindelo Masikane live for us in the High Court in Pretoria. Let's leave it there for now.